Good day, Doctor. We are from Group 4. Our topic for today is marital rape. Section 2 of Domestic Violence Act 1994 defines domestic violence as any form of abuse which include physical, sexual, emotional, psychological, economic harassment, or damage to property. There is two types of law that governing the issue of domestic violence in Malaysia. The first one is Domestic Violence Act 1994. It is under three protections: Emergency Protection Order (EPO), Interim Protection Order (IPO), and Protection Order (PO). In penal courts, the offender will be liable if he causing hurt to have sexual intercourse under a valid marriage. Marital rape is the act of sexual intercourse with the spouse without the consent. The effect of marital rape is the victim will face short or long-term psychological implications. The victim will lose confidence in their marriage. The children will have poor performance in their academics. And lastly, the family member will be traumatic. The problem is the Malaysian legislation is silent in the issue of marital rape.
Taking the lead into the position of Malaysian law, Section 3 of the Domestic Violence Amendment Act 2017 stipulates that the particular act is to be put together and read along with the penal code for the offences committed by the offender or abuser, particularly if they cause physical or emotional harm to the victim. As Malaysia does not recognise marital rape, there is no law that specifically addresses this subject. In relation to this matter, our Malaysian legislation is that grants the spouse marital immunity. In Section 375 of the Penal Code, the offence of rape between a man and his victim is described. However, it is clearly stated in this exception of the particular section that constitutes that any sexual engagement between a husband and his own valid wife under a legally recognised marriage recognized by the written Malaysian law will not be considered rape, even if it was performed under duress. This gives the husband the entire authority of marital immunity to do anything they want to their wife's body, even if she did not agree to this activity. Even though there is no specific provision regarding marital rape, Section 375A of the Penal Code states that any man who during the subsistence of a valid marriage causes hurt or the fear of death to his wife or any other person in order to have sexual relation with his wife shall be punished with imprisonment for a term that may extend to 5 years. This provision applies, however, only if the husband has caused a damage to the wife during a sexual encounter without mentioning consent as a need. This is something that both spouses should take pleasure in, since sexual intimacy is not the only aspect of marriage. The partner who had not agreed to this behavior may face repercussions as a result of the lack of permission. For both provisions, there have been no cases that qualify as marital rape because it hasn't been recognized. Even for Section 375A, there has only been one case involving a foreign couple which was later dropped. But one of the people who was raped by a spouse was interviewed by the Thomson Reuters Foundation. Nilambika has no choice but to let her husband treat her in a horrible way. She had been hit by her husband more than once by the time she decided to end their terrible marriage. When her husband found out about her choice, he was even more angry and he raped her mercilessly on the couch where she slept every night. Her actions did nothing but make things worse in their marriage. She had said that it was about him showing how powerful and in charge he was. I got through it, but something inside of me died, showing signs that she had been through had caused her mental F to be off. Even if she went to someone else's house to hide, her husband would still tell her to come home. She also said that she knew her husband wanted to use her body however he wanted before the divorce was finalized, because he thinks he has the right to do so as her husband. She goes on to say that she didn't even call the police because she knows that they cannot help her in any way. Hearing her last words shows how little our laws do to help people who have been abused in its way to escape their reality. Marital rape is not a criminal offence in Malaysia, and hence, victims of this crime are not eligible for domestic violence protection. A person, however, might also show that they were the victim of domestic abuse by showing the wounds they have sustained. As a direct result of the offender's sexual aggressiveness towards her, the victim has experienced psychological damage. Both their physical and emotional well-being are negatively impacted by their belief in themselves as worthless and self-conscious. With all of this proof, the victim may show that the offender's conduct of domestic violence has resulted in psychological or emotional harm to the victim. Thus, the victim may apply for domestic violence protection under emotional abuse.
Next, let us look at the development of marital rape in other countries. In the United States, cases of marital rape continue to be one of the most underreported crimes, although marital rape is criminalized in the state because the retributive system of justice practice does not guarantee safety of victims, especially when the offender has been released from bail. Alternatively, the restorative system justice applied in Thailand, New Zealand, and Canada shall be introduced, under which offender is observed to change himself through rehabilitation programs. Plus, it provides support for the victim through recognition of their losses. Additionally, a timely compensation mechanism has been introduced in the Northern Ireland, Australia, Canada, and United States, which is the compensation program funded by the state for instant financial assistance to victims of domestic violence without going through court process to ensure victims' well-being after leaving the abusive husband. However, victims in countries which do not recognize marital rape often escape their countries to run from the abusive husband, as illustrated in the Hong Kong case of PA and torture claims appeal board, where a national of Sri Lanka refused to return to her country for fear to be harmed by abusive husband. Normally, incidents as such stem from society's expectations toward women to condone men's abusive attitude, allowing women to be oppressed. Thus, there is a developing international trend toward criminalizing marital rape. For example, United Kingdom has announced the principle of irrevocable consent in marriage since 1993, establishing that both partners are supposed to be treated as equals. However, barriers like social, cultural, and legal obstacles prevent victims of marital rape from obtaining justice.
Good day, Doctor. I'm Ho Kai Man, metric number 279215. Now, I'm proceed to the reforming the law of marital rape. There are 4 ways in reforming the law of marital rape, which are, firstly, we need to give rise to pressure by allowing husband to be condemned of raping his wife. Secondly, we can have an agreement on something as essential as intercourse. Thirdly, the judges can have to be informed of the threat of condemnation on the plaintiff's proof. And fourthly, under a situation where the wife refuses to testify, we can overcome it by reform the law of proof, such as that in English Police and Criminal Evidence Act 1984. Moving on, in criminalizing marital rape, firstly, the prosecution must only be brought with permission of public prosecutor. Secondly, the court must contemplate bringing the criminal law along with the current view of the wife's duty within the marriage. And thirdly, criminal law must carry out an educative function by rescinding several archaic statements upon which current law is based. And fourthly, the judges must distinguish that today's marriage no longer renders a husband an unlimited right to his wife's body. Next, under loopholes of marital rape, it is neither clearly permitted precondition to marital actions, nor does it penalize wrongdoer who forces intercourse when permission is not granted. Secondly, the problem of permission is not raised at all. And thirdly, it does not offer a minimum level of punishment. Moving on, the punishment is less severe than rape. And next, the component of permission is considered as insignificant. And lastly, the exception of Section 375 of the Penal Code gives absolute power to the husbands towards the wife. There are a few importance of reforming law of marital rape. Firstly, is to prevent the wife to think that the husbands have deceived their trust. Secondly, to avoid the wife continually frightened by the scenarios of frequent attack and think that their homes are no longer that safe. Thirdly, it is to prevent women in losing their faith in their marriage. And fourthly, it is to prevent the children got influenced by their parents. And lastly, it is to avoid most victims silenced by their dilemma. As for the laws to amend, the marital immunity under Section 375 of the Penal Code must be removed if marital rape is to be treated as crime deserving of punishment, as well as include the permission and minimum level of punishment to the wrongdoers under this section. In short, criminalization of marital rape has to be put into operation and performed instantaneously in order to prevent breakdown of marriage and family relationships in Malaysia. Thank you.